Damas should have never been pushed through the court system, and as a result, his death sentence is unreliable.
In today's oral argument before the Florida Supreme Court, attorneys debate whether Mesac Damas was competent during his trial sentencing and whether his death sentences can be considered reliable. The argument focused on mental health evaluation, the role of counsel, and how the justice system handles claims of incompetency during capital cases. We'll walk you through the exchange and highlight the key issues raised on both sides.
He was denied the fundamental protections of the Constitution. He was not competent to proceed during his trial, court proceedings, and he was not competent during post-conviction. And when he was run through the system, he went through without the protection of the counsel that the Sixth Amendment guarantees. Counsel should have acted as his advocate and contested his competency. If Mr. Damas was going to be forced through the courts, his counsel should have timely developed and presented his mitigation. After counsel failed him, the Constitution gave him the right to the effective assistance of appellate counsel, and that counsel failed him as well. Mr. Damas had a number of competency proceedings, and in 2014 he was found incompetent and he was sent off to GO care for so-called treatment. And so he was there for about 20 days, at which point they ran him out of the treatment center and sent him back to the courts. At that point, rather than contest the findings of the doctors that were reappointed to evaluate him, his counsel merely not only stipulated to considering the reports, one of which was by Dr. Mandelblaut, which was a scurrilous report, which was basically a character attack on Mr. Damas. They also stipulated to competency itself.
If we leave aside the Mandelblaut report finding him competent,
in death penalty cases, competency isn't something defense counsel can casually agree to. Stipulating to competency without challenging the report is extremely unusual, especially when the same doctor has previously found the defendant incompetent. That's why this argument is important. The attorney is claiming the entire process was unreliable from the foundation.
Don't we also have the Herkov, Scharf, and McMurray, and Kling, and Harper reports?
Well, he
finding him competent.
He was found competent earlier.
So I know those are. I'm sorry. The last Harper report is August 26th of 22, and there's another one on August 30th.
That was for post-conviction.
Right.
Okay.
So I mean, you're doing a great job arguing for your client, but I think it would be disingenuous to ignore, by my count, 8 different reports, maybe 9, finding him competent to proceed.
Well, he was found competent to proceed, but he was found competent by Dr. Herkov and Dr. Scharf, who earlier, right before that, said he was both mentally ill and incompetent. Then all of a sudden he gets placed.
So the fact that they had earlier found him to be incompetent, it seems to me, actually strengthens their subsequent determination that the treatment had restored his competency. I mean, that's why he was sent to the treatment facility to restore his competency, and they determined that whatever had been done there had been effective in restoring his competency. So the fact that they had previously said he was incompetent, rather than undermining their subsequent determination of competency, actually strengthened it. They were willing to determine him to be incompetent, but that's a competency has to be determined at a particular time. But am I wrong in thinking that after February of 2014, when there was a determination of incompetency, that there were just one determination of competency after another? 2014, 2017, 2020. And then up through till 22.
Well, there was competency in post-conviction because counsel moved and actually did a hearing on that. And that's what counsel never did for Mr. Damas when within 20 days he's miraculously cured. And if you look at the reports of Dr. Scharf and you look at the report of Dr. Herkhoff, who had said I think Dr. Scharf said he had bipolar disorder and Dr. Herkhoff said he was on the schizophrenic spectrum, then all of a sudden after this scurrilous report by Dr. Mandelblatt.
I keep calling it scurrilous, but the report found that your client was malingering, and there was 5 weeks of clinical observation that went into that report.
This is where the court pushes back. Several doctors concluded the defendant was malingering, essentially faking symptoms. The attorney is arguing those findings weren't properly challenged, and without a full hearing, the court relied on reports he believes were incomplete or unfair.
Why do you call it scurrilous?
Well, it was a personal attack on Mr. Damas. If you read the whole report, that should not be an
personal
expert
attack. Obviously, it's personal because it is personal to Mr. Damas's mental state. But how is it an attack?
It's an attack on his character. If you look at that, if I put that in a brief, I would be accused of making an ad hominem attack, and that's exactly what Dr. Mandelblatt did in this case.
But the reality is, if he determines that he's malingering, that is an attack on his character. I mean, that is, and there's just no way around it.
Well,
but we know, I mean, that people do malinger. They aren't always malingering, but people do malinger, and it's an established category of evaluation in these sorts of examinations. And so, the bottom line is, after they washed him and they saw what was going on, they determined he was a malingerer.
Well, I don't think Dr. Mandelblatt spent 24 hours a day with him. This is reports, and that was never part of a hearing. That could have been contested if counsel had just acted effectively. But what Dr. Mandelblatt, what she did was created a narrative, and a false one, that Mr. Damas was volitionally obstructing the court system. And then I believe my colleague's going to get, opposing counsel is going to get up and argue that this was some sort of gamemanship. But what game is Mr. Damas playing other than trying to get himself killed?
This is one of the most striking parts of the argument. The defense suggests there was no incentive to fake symptoms, that his behavior was aligned more with an untreated mental illness than manipulation. This goes to the heart of whether his sentence can be considered reliable.
And it could have been, and there were opportunities. We're talking about 2014 where he was found incompetent, then found competent again. Time goes by and those reports become stale. And so what happened in 2017, it wasn't counsel that moved for him to be evaluated for competency. It was the judge, the same judge that eventually found him competent, who ordered the competency, was conducting his own investigation on whether Mr. Damas played chess and things of the like. So there was never a proper hearing where counsel contested the idea that this was malingering, that this was volitional. And in fact, in 2014, counsel stipulated the competency, which that's not supposed to happen.
Let's say we agree with you that more could have been done, just hypothetically, to explore the claim of malingering. Am I correct that at the end of the day, the trial court's denial of relief here is a matter of abuse of discretion?
Yes, Your Honor.
Okay,
it's contrary to the facts.
Working with that, you'd have to show that no reasonable judge could have considered the more than half a dozen consistent competency findings and then have determined, okay, I'm going to find this person competent.
No, that would be for the competent. This is a Strickland claim. So we're looking at the performance of counsel, and counsel was deficient by stipulating the
because
competency.
It wasn't raised on direct appeal because it was waived on direct appeal.
Well, they didn't. There wasn't a whole lot raised on direct appeal, which I can get to.
I mean, that gets to another problem about what's foreclosed here. But
okay,
I digress.
But Mr. Damas needed a hearing where counsel could have cross-examined Dr. Mandelblatt, where counsel could have put on, as I cited, a competent expert like Dr. Agarwar, who could explain why it's not just him being obstructive, how his perhaps sincerely held religious beliefs interact with the schizophrenia spectrum. And that was never heard, and that was never done. And then in the end, nobody could help Mr. Damas because he was so mentally ill. He couldn't interact with his counsel. At times he would, and at times he wouldn't, which is consistent with his mental illness. The fact Dr. Mandelblatt citing things like he went and got banking when he was at the center. Well, it's not like it's 24/7. He's acting out. It's when certain periods come, it gets very acute. He cycles in and out of this psychosis, and at the end of the day, the state of Florida, the judge sentenced an incompetent man to death, and it did so without properly considering his mitigation, and that brings up the other claims where Mr. Damas could have shown that, in fact, he wasn't malingering. He had a mental illness. It became a whole thing in that sentencing order that the sentencing judge discounts his mental illness when in fact he's schizophrenic, and that was found by Dr. Aguilar, and that was also found by Dr. Herkov at one point on the schizophrenic spectrum. So we have that, and then multiple doctors asked these attorneys, please get us these very precise scans and we could see the schizophrenia. And that wouldn't necessarily rely on Mr. Damas, and those pictures would have been able to pinpoint and show that, in fact, he does suffer from a mental illness. It's not just volitional. It's not a personality disorder. He's severely mentally ill in addition to being brain damaged. But the court doesn't allow the scans to be done and doesn't fund Dr. Wu to come in and to do that. So instead, they go to a Spencer hearing, at which point they put on Dr. Rubino, who's a neurologist, who has no business testifying that Mr. Damas has schizophrenia. He could only look and say there's parts of his brain that was consistent. And that doctor, too, Dr. Rubino, still wanted those additional scans because it would have been a more precise picture. And it would have been something that the sentencing court could not have discounted and denied Mr. Damas a fair penalty phase. His death sentence is beyond the Eighth Amendment. Because of Mr. Damas's incompetency, none of the rights could protect him. It's unreliable, his sentencing, and at the end of the day, it should be reversed.
Competency evaluations can shape the entire outcome of a capital case. Let me know your thoughts in the comments. Please keep it respectful. If you found this breakdown helpful, feel free to subscribe for more courtroom analysis.